Judge.
Did they all say that?
You gotta do the rest. One and three. One. Either one or three. One and three.
Are we working off of a second amended motion to revoke probation? Is that
That's mine.
where we are on this? Okay. Because I've got it, but
That's my
I didn't know if
understanding.
that was the most recent one.
That's my understanding as well, Judge.
Wow. This,
Leading to allegations.
not 18, but 19 violations here. I've done this a long time. I've never seen a motion with that many.
Punishment.
But that does not scare me.
Yeah, it's,
18-30652 is called the State of Texas versus Desiree Monique Boyce. Is that you?
Yes, sir.
Present with your attorney, Mr. Turk, the state's attorney, and the probation officer is here. There is a second amended motion to revoke probation that has been filed. Shoot, that was filed over a year ago. That's what we're going to be working on. Do you understand?
Yes, sir.
Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Lower your hand. Does the defendant waive a formal reading of this second amended motion to revoke probation? Can we proceed in summary?
yes, Judge.
In summary, ma'am, this second amended motion to revoke probation in this cause number 18-30652 alleges that on August 26th, 2019, well, going on 7 years ago, in this Criminal District Court of Jefferson County, Texas, you were sentenced to 5 years in prison. That was suspended for 10 years probation for the state jail felony of unauthorized use of a motor vehicle.
Yes, reset.
And it was a state jail felony, but it was punished. It looks punished as though it were a third-degree felony because you had two prior state jail felony thefts in 2018, an unauthorized use of a motor vehicle, and a state jail felony of theft were the two prior convictions out of Bayard County that were used to bump the punishment range up from what would have otherwise been a state jail felony as it is in this case, but it is punished as though it were a third-degree felony, and you were looking at up to 10 years in prison. Is all of that true and correct?
Yes, sir.
We're not going to do all of these. Just give me the bullet points. Which one's she going to plead to?
1 and 3. And the state would abandon the remainder, Judge.
I'm sorry, it's 1 and what?
3.
Okay. Well, there's a lot of effort.
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense.
That was put in here because, I mean, this is 1 and 3 were 2 amended motions ago. Were already in there. We could have moved this thing a long time ago.
We have to go.
All right. 1 states you provided a urine sample on or about March 5th, 2021 in Bayard County, which showed the presence of marijuana in your system, which is a violation of condition 10 of your probation order. And get into it. Looking for the probation order. There it is. On the right side. Probation number 10. Order that the court signed when we placed you on probation. Do not use or possess any drug. Use of, possession of, and prescriptions of any and all medications must immediately be disclosed to your probation officer. Is allegation 1 true and correct as it is alleged?
No.
Yes, sir.
You're pleading true to that
Yes, sir.
voluntarily and because it is true.
Yes.
Number 3 states you failed to submit to alcohol and or drug screening on or about November 23rd, December 21st of 2020, March 3rd, April 9th, 2021, at the direction of Bayard County Probation Office, which is a violation of condition 25 of your probation order, which is submit to alcohol and or drug screening at the direction of the probation office. Is that allegation 3 true and correct as it is alleged?
Yes, sir.
And are you pleading true and correctly this as well as allegation 1?
Yes.
Voluntarily and because it is true as it is alleged.
Yes, sir.
Do you understand that a voluntarily and knowingly made plea of true to one or more violations of probation, that is enough to grant a motion to revoke probation, such as the second amended motion to revoke probation? Your probation can now be revoked, and you can be sentenced to no less than 2, no more than 5 years confinement in prison. Knowing that, do you insist on pleading true today?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true.
Yes.
While looking at an agreement that has been reached in your case, where your probation would be revoked.
Because it's still a state jail. It's still a state jail. Yeah. So
It's a state jail.
yeah. So
Yeah, and this is showing 180 days in the county jail. It's got to be 180 days in the state jail, right?
And I tell you, the thinking behind it, Judge, is we want to punish it under 1244 of the penal code as a misdemeanor.
I didn't do that.
Well, that's what we would recommend to the court, and I tell you why. She has a sufficient amount of jail credit on the county side to satisfy this.
No, hold on.
plea.
I didn't do that at the outset of the crime. That's when I should have done it.
Understood.
When I said that I sentenced her to confinement in the state jail. That was at that point in time when she was sentenced was when 1244 should have arisen. It
Yes.
didn't. But I mean, you got no less than 180 days up to 2 years in the state jail.
Yeah.
I mean, that's what needs to be in there, not the county jail. I don't think I have the authority to do that. But what do you want me to do? Change this to 180 days in the state jail? She's going to be given credit for all time she has served, whatever that is. Do you know how much?
Over 400 days.
She's got over 400 days. She's not going anywhere. They're going to send her right out.
I'm going to ask her.
Go ahead, do it.
That's fine.
I don't get to make those decisions unilaterally.
Putting 180 days in the state jail in lieu, with everybody's agreement,
No objection, Judge.
in lieu of confinement in the county jail. Is this your understanding of the plan, then?
Yes.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes.
Let me show you what's marked as State's Exhibit 1. Did you sign that?
Yes, sir.
And understand it, discuss it with your attorney. Are the contents true and correct here?
Yes, sir.
States Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. This also states, if I follow this agreement, you have waived all rights of appeal. I am going to do this. Anything else to add by the parties?
No, nothing from the state, Judge.
Not, I'm going to find that there is sufficient evidence supporting the second amended motion to revoke probation under cause number 18-30652 to grant it by preponderance of the evidence or greater as allegations 1 and 3 are proven true. And your this second amended motion to revoke probation is hereby granted, and your probation is hereby revoked based upon the court's findings of these violations of probation. I'm following this agreement proposed and authorized by the parties. You are hereby sentenced to confinement in the state jail to a term of 180 days. You will be given credit for all time you have served. You understand what has happened today.
Yes, sir.
All right. Do well. Thank you. And the state's attorney, what are we doing today?
Your Honor,
So now-
state has made an offer. My client is adamant to do this and want the trial, so set up for the trial.
We get a plea rejection, it's on the record. Oh, yes, that's good. Okay.
So the victim in this case is a sibling?
Sister, yes.
Sister? Her perception of the situation is completely different than his. Let's see.
Yes, Your Honor.
She tried to flee from him, catches up with her, strikes her in the neck with a closed fist, attempted to get away, slapped her in the face, grabbed her by her hair, pulling her hair, drug her on the ground, then stood up, grabbing her and placed his arm around her neck. Placed the crook of his arm around her neck and squeezed. You know what you do when you squeeze somebody's neck? There's only one intent: to kill. Breathing comes in handy for humans. When you put somebody's hands around neck and squeeze, the only real reason you're doing that is to kill, that attempt to kill. So you're charged with the third-degree felony of assault, family violence. But this isn't your first rodeo, is it, with the law? See, you were convicted in 2019 in this court for illegal possession of controlled substance. After that became final, you committed the offense of evading arrest or detention, and were convicted of that in 23 in the court next door. You're looking at no less than 25 years to life imprisonment. This is a habitual felon. You understand? I can understand. Yeah, so. And it is illegal and a violation of the bond conditions, the orders of the court in all cases like this to have any contact with a victim. Do you understand that? Nor anyone on your behalf. If I find out about it, I'm going to ask the state to indict for another charge and add that, because you're not supposed to talk or have any contact with a victim. You haven't, have you?
No, sir.
Well, that lady wanted you prosecuted, and I can understand, especially if there's an attempt to kill.
Never
Set it for trial. I'm sorry, you interrupted, but the grand jury accuses you, and that lady states you squeezed her neck. Were y'all just playing? That's a rhetorical question. You squeeze somebody's neck, there's only one reason to do that: an intent to kill somebody. Everybody on the planet knows that, apparently, but you. Set it for trial. And let me find out from the state if he has any contact, because I'm going to ask that another charge be brought. Okay, that is all. Let's see. What's next, John?
Trial docket. I don't know if you want to give them one of their trial attorneys off the trial.
I'm talking about Jadrian Manning is what's next on this docket.
We'll talk.
Jadrian Manning.
Yeah, this was reset for a couple of weeks ago. We're still working on that one. If we can get if you then we can get a few more weeks just to get that straightened out. It's old, but he was in.
Well, no, but nothing. It's over a year and a half old. He's sitting in the ground.
He was in, mentally,
I know, but it's languishing. It's a year and a half.
but,
It's assault on a peace officer. We're not gonna, what are we gonna do? It's been a year and a half. Everybody knows where we would be heading. Come on.
give me 1 week, Your Honor. Be back next Monday.
Reset unbook. Denise Woods.
Okay.
Actually, I think it's the week. It's just,
What are you gonna do on that?
Your Honor, one of them was an MTRP. We need to set that for a hearing. I've talked to my client. I've talked to Mr.
Are we ready for a hearing?
I don't know if we're ready.
It's not ready, Judge. I asked for at
When
least
can
3
you
days.
be?
I
Yeah.
asked for at least 3 days notice.
I'm doing more than that. I'll pay you. You still leave.
Thank you, Judge.
Be ready next week. June.
It depends on my officers or the witnesses' availability.
Yeah.
Judge.
Today is,
That's the week I'm going to be gone for my CLE.
No, that's.
what's available?
24th, yes, 20 through 24th. Yes, I'll be here on 24th. Yes. The week of the 20th, I'm here, but then I'm out.
Okay, but not the following.
Yeah, that week, anytime that week is good. Obviously, I'll be present today.
I'm going to say it. I'll check on my witnesses.
If you have, I have just.
Well, it's a drug allocation.
Yeah, well, I guess.
It's a drug, it's a drug, it's a
Yeah.
drug.
Yeah.
It's everything here.
Yeah.
She got 3 cases in it.
Yeah. No,
Smoking with methamphetamine. Just, the odor will rise. It's just, I can smell it from here. And it's in the words. When do y'all want to set this for?
7:24. 7:24.
Y'all can speak if y'all want.
No objection, Judge.
That's this week I'm here, Your Honor. So,
Okay.
yes, I'll be available.
Set for then. Thank you.
It's afternoon.
That's 3 cases. It's Woods, right? I have, Brent, hey, Renee Avila, what did we do? And Javante Bailey?
I believe he's signing up to plead to the misdemeanor too. Mr. Bailey, Drasky.
The plea is complete, Ms. Compton, just let me know, so I'm doing the dismissal on ours as we speak.
Okay, and what's Renee Avila?
He's not going to take the 2 years, but he wants to ask the court for a bond reduction.
Oh, and 30.
It's 30,000 at this point. 724.
Okay, let's see.
It's a total of
And John Gillory?
He's one that wants to be pro se judge. He's told me from the get-go, he wants to be pro se.
Pro se for 2. Okay, these are trials, right? Not MTRPs, trials, right?
Gilroy, I suspect, but he's told me
We're going to take him.
he doesn't know them all.
Let me get to Bailey and Avila. Is Bailey ready?
Bailey's going to be dismissed.
I don't have it. Yeah, I'll send it over.
Okay, Javante Lee Bailey to be dismissed, correct?
Yes, sir.
Okay, let me know when Renee Avila. And that's a,
He would like to reduce his bond
okay, Avila,
from $30,000.
Yes, Your Honor.
oh no, yeah, he's right, he was here before.
Yes, sir.
Today.
Now, here's where this hearing takes an interesting turn. The judge has already pointed out something highly unusual: 19 alleged probation violations, something he openly admits he rarely sees in decades on the bench. Yet, despite that long list, the prosecution narrows the case to only 2 violations. That tells us this hearing isn't about proving every allegation. It's about proving enough to legally revoke probation. Keep an eye on how the defendant responds, because one truthful plea could completely change the outcome of this case. And here's a question for you. If you were offered a deal like this, would you take responsibility immediately or fight every allegation in court?
All right, we're staying.
That's
Big, that's me.
She's good.
26 CR 273, this is called. The defendant Renee Avila is here. He's with Mr. Turk, his attorney, and the state's attorney. Defendant is charged with a third-degree felony of engaging in conduct two or more times that constituted an offense under the Texas Penal Code, and by communicating directly with the victim in a threatening, harassing manner, texting, stating the defendant hates her, threatening to fight her, and he would urinate on her grave. Yeah, that's, I remember. Knowingly and repeatedly calling the victim's phone multiple times and going to and near the residence of the victim. And this constitutes, according to the grand jury, a engaging in conduct two or more times, which is a violation of bond or protective order rules, and thus is a third-degree felon under the Texas Penal Code, section 25.07, which states, among other things, that it's an offense in violation of a condition of bond set in a family violence matter. It directly communicates to a protected individual or a member of the family or household, or threatens, and those are yes statutes that the legislature enacted to keep the family unit from being placed in violence. Okay, so what are you asking?
Judge, Mr. Avila is Avila? Avila, that's what I thought. Is asking to reduce his bond to say $15,000 so we can get back to work. You know, not necessarily to support his family indirectly, because I mean they need support. He's not supposed to contact his, I guess, ex-wife's wife.
She's my wife.
But directly, but he does have an obligation to his children to support them.
I have an obligation to her too.
He does, and I mean, but he can't contact her because of the pending cases. So that's what I'm saying, judges.
Well, whose fault was that?
Well, Judge, this is a bond hearing. He does have
the point is that you're asking for a reduction in bond, which would be him being a reduction of his requirements for being released, but he didn't follow the court's rules in the first place. That's why he's here. Why would he follow them now? If I reduced his bond, why would he follow any rules? I mean, he's in the grand jury indicted him. Probable cause was rendered that he did not follow the bond or protective orders of a court.
that is the allegation, Judge.
Well, why would I think he would follow any I would guess?
You want me to speak? All right.
I don't care what you do. I'm just making a comment.
I would definitely follow the orders because
You mean like,
no, because
but you're here for a different reason. You're here for violating orders,
Yes, John. I understand, John.
What's they say?
Judge, if the court is inclined to grant the bond reduction, I'm going to ask for a GPS monitor before he is released, as well as no contact with that our complaining witness. But I am also looking at his history of of noncompliance, and I did not have an opportunity to do any additional research as to his bond release.
Your request is denied, but I'm going to try to move this thing fast. When can y'all be ready for something? A hearing, a trial? Because he's been
He wants a trial?
sitting around a while.
At this point, yes.
Okay.
How long you been in jail?
5.5 months, sir.
So I guess we'll just reset it for trial, Judge.
Okay, well, I'll place it on the trial docket, okay?
Yes, sir.
Let's try to get that done that way. Thank you. That is all.
Counsel now, you have to go say. I'm going to be I am.
All right, we call the two cases, 24 CR 79 and 25 CR 434, the state of Texas versus John Gillory, also known as John Gillory III. Is that you?
Yes, sir.
Okay. On the older one, this is 2.5 years old. You're charged with a third-degree felony of unlawful possession of a firearm by a felon, and okay, it's a habitual felon status, right?
That's my understanding, Judge.
We go back 1, 2, 3 convictions in 07. Thereafter, a conviction in 09. That was in 09, habitual felon status. To 10 escape conviction. And then in 22, a conviction next door out of the 252nd. And then 25 CR 434, another unlawful possession of a firearm by a felon conviction, charge with 1, 2, 3, 5, 6 paragraphs of prior convictions. Actually, most of them are unlawful possessions of a firearm, and here you are charged with 2 unlawful possession of firearms. Are you represented by anybody, or are you representing yourself?
No, sir. When I came on January the 5th, I requested to proceed pro se, and I also filed a motion to be admonished to proceed pro se amongst other folks.
Okay, you can represent yourself.
Your Honor, if I may, I'd ask that the court consider appointing a shadow counsel in case there is a question.
Somebody will be appointed standby
Stand by.
if necessary.
Okay. One other
He
thing.
can represent himself as
Yes,
long as he wants to,
Yes, sir.
as long as he follows the rules. And,
Yes, sir.
and
I don't
but
know.
I'll appoint somebody as sitting with him so he can confer if necessary.
Yes, sir. One other thing, I'm sure the court has admonished the defendant about the habitual offender status. The state would also be seeking.
I'm sure I did, because we've been up here before. He knows he's looking at a minimum of 25 years confinement in prison if he's found guilty of all of this, up to life imprisonment.
One other
And
thing.
probation is not an option.
And one other thing, Judge, the state would be seeking to accumulate or file a motion to stack these sentences as well, Judge. I don't know if there's an admonishment the court would want to give on that as well.
Well, you can talk, you can direct him. He's listening, and yeah, he's going to represent himself, so you can speak to him directly, and
Yes, Your Honor.
you hear whatever you got a most recent sentence according to this in 22. 22. What were you sentenced to out of that court next door?
I showed 3 years on that BOCS, Judge.
Well, he's done that. That was in 22. He's completed that, hasn't he? Is that right? You've completed that sentence? Okay. So what is the sentence you're talking about that would be stacked?
I am showing 2 pending unlawful possession of a firearm cases, Judge. One in cause number ending in 0079, the other one in cause number ending in 434.
Where? What court?
This court.
We have right now.
Yes, Judge.
He got one while I'm on, but that's fine.
Oh, okay. So you're talking about you're going to request that 24 CR 79 and 25 CR 434, if he is convicted of these 2 offenses, those sentences be stacked.
Correct, Judge.
Okay, okay. I didn't know if there was some other jurisdiction out there that he had another. Okay, so we're all here. Okay.
Your Honor, I like to object to those indictments. In 24 DCCR 0079, there was no warrant for the seizure of my person, and there was no exigent circumstances or reasonable suspicion. I was a passenger in a regular routine traffic stop. There was no reasonable suspicion I was armed or dangerous to the officer. There was no probable cause to go beyond a traffic citation.
Bring that up at trial.
I filed a motion to suppress the evidence which should be in.
Yeah, I reviewed those. Anything else you want to add on them?
Sir?
Anything else you want to add to those?
Not to the motion to suppress. I just asked that the court consider the motion to
There, I
suppress.
considered them. Yeah,
Yes, sir.
they're going to be denied, but it's something that you could appeal later if you have to.
Okay, so the motion to suppress is denied, Your Honor?
It is. They are.
Matter of the grounds that.
No,
Okay.
insufficient
Yes.
evidence presented to support the motion.
Okay, and in the other charge, I have 2 affidavits that I would like the court to consider and take judicial notice of.
For what?
For the firearm that was found in the car.
You can bring that you can bring up at trial. But remember, the rules of evidence are what they are.
Yes,
I was on the evidence committee that was on.
already on file, and I'm just asking that the court consider them.
Okay, just follow the rules of evidence and the code of criminal procedure, like all others are supposed to. You're going to be held accountable for that. That's the problem in self-representation is too often that does not happen. But I was on the rules of evidence committee that wrote the rules of evidence, and I'm sensitive about.
If you found this courtroom case as fascinating as we did, don't forget to hit that like button, share your thoughts in the comments, and subscribe for more real courtroom breakdowns where we explain the law behind the headlines. Thanks for watching, and we'll see you in the next one.
Following it, but just follow it. And, then you'll have a chance to be heard, and then we'll let the jury decide. When when is this set for?
Yeah, we had removed it off the trial document.
It needs to get off.
Judge, also, could I receive the order so that I could appeal the pretrial denial of?
No, their orders are on the record.
Okay, so I could just file my notice to appeal? That,
He didn't do.
Yeah, but you got to order it through the court reporter. I'm not going to tell you how to do that. You're representing yourself. That's your business. But it's oral orders and they're in the record. They're made. Yeah. Anything else?
Nothing from the state, Judge. Thank you.
What's the date we've got this thing set?
Judge, I'm ready to, whenever, we don't try
Do
that.
you have an idea? So we can all know to get ready.
The 10th is out.
What's the date on his indictments? The earliest one?
The earliest one, 1/24/24.
Okay, that's 2.5 years. Yeah. Accelerate it.
17th of August.
August 17th. How's that?
the 17th, that's fine, Your Honor.
Good.
Thanks, Judge.
Judge, I also requested discovery. I don't have any information pertaining to my case.
I will make a note, and I'm happy to make it available, Judge. Because of this pro se situation, I'm going to have to work through the logistics, but I represent to the court that I'll make it happen.
Yeah. I'm not sure what wouldn't be disclosable. I mean, that's kind of open file on this.
That's what I'm thinking. Just
On
bring him over to
unlawful
jail because we don't want
possession
that
of a
material.
firearm.
We don't want that material in the
Yeah,
jail.
let him look at it, and if you need copies of things,
Well,
give it to him.
my understanding is they don't like copies of that stuff over at the jail.
Yeah, not allowed to have it.
That's what I'm told.
Well, what does he do?
Come over and view it in person.
Well, he can make his own notes. What about that?
Yes, sir.
Yes.
Well, isn't that like a copy?
They just can't bring the discovery to the jail.
Oh, you're saying they don't want to discover, okay.
He has to come here and go through stuff.
That's my understanding, Judge.
Well, hold on. So he can come over here. Can we make copies of him here and give it to him?
The district attorney's office would provide all the discovery to him and then
Is that-
have him sign off on it.
How-
We've done with other people.
Okay, hold on. There are two ways. He can either write all this stuff down that you're going to give him, or can you make copies for him?
Judge, that's the logistics I need to work through. My understanding is the jail does not like for those defendants to have copies, actual copies over there.
Why not? I don't know.
Shut him, toilet, back everything.
Well, and even more than that, I think there's other issues, Judge, about having that information floating around out there, which is with names of witnesses and addresses and, that kind of thing.
You're not worried about lawyers having all that information?
That may be an issue as well, Judge, but as far as the instant case, we'll work through the logistics.
Okay, but see, here's the deal, is he can write it down. He can write all that stuff down and carry it with him. I don't know what the difference is. If he writes verbatim, he's got a duplicate copy of it. And how do we explain? Well, you can't have the regular copy, but you can make a duplicate copy yourself and you can carry it with you.
Just trying to follow the rules, Judge.
Well,
I'm a rule follower.
I know, but I always thought rules had to make sense too, so to enhance people to follow.
Excuse me, Your Honor. And also, just for clarification, is that all the motions that I filed, are all of them denied?
Yeah. What other ones do you want to bring up? I'm not going to tell you how to do your job, but you just don't file motions. You have to present them in a way that meets the law. I'm not going to tell you how to do that. You've decided to represent yourself. It's not my burden to come forward.
I understand, Your Honor. Is there
Anything else you want to say?
Evidentiary hearing?
No. We're going to have an evidentiary hearing at the trial.
Okay.
Anything else?
Nothing from the state, Judge.
That is all. Anything else? Any other cases?